Good morning and thanks for joining everyone. We'll be getting started here shortly. We'll just let folks have a couple of minutes to join the room. There is a chat box and a Q&A box. Our preference is that we use the Q&A box for any questions you have, and we will tackle all of the questions at the end of the session. We will also be making the recorded presentation and PowerPoint available to all registrants via email at the end of our session. We'll get started here shortly. Just another short reminder, if you just joined the session, we will be making the PowerPoint available as well as the recording to all registrants. That usually takes a little bit of time to render, but as soon as it's available, we'll send that out via email. And I will get us started here. So thank you for coming to our, I believe this is our fourth quarterly sample packet webinar. Today we'll be discussing the March 2023 packet, and we are joined by Bob Turk, who is our Chief Legal Counsel of District and County Office of Education Legal Services. I will also be presenting. I'm the Senior Director of Policy and Governance Technology Services. We'll have Barbara, who is the Senior Policy Manual Consultant, Dustin, who is also a Senior Policy Manual Consultant, and Mariela Martinez, who's the Senior Legal Services Attorney, also joining our panel. So I will hand it over to Bob, who's going to give us some information on legal services.
Hey, thank you, Tazita, and thank you all again for joining us. It's such a privilege for Mariela and I to get to be a part of this webinar and talk about not just policies, but really the changes in law that have impacted those policies as part of our legal services program. And for those of you who aren't familiar with the program or haven't signed up yet, we just want to give you a little bit of information about it because it is relatively new. It's only existed for about a year or so. What the program does is basically allows us to provide direct legal advice and counseling to districts and county offices that sign up for the program. This slide shows you a couple of the resources that are available and some of the benefits. It's a very cost-effective program. We really did it to be able to provide additional services to our members. And in the policy context in particular, I'm sure some of you may have called with a question, for example, about what does this policy mean or how do we implement it? Can we change it? And you get some response from our consultants who give you guidance and they tell you, how does it interplay with your policy manual or CSBA sample policy? But they can't give you legal advice. So sometimes they maybe have had to refer you out and say, I can't provide that legal advice. You need to speak with your legal counsel. So this is one of the ways that we can help out with our legal services program is if you have those kind of policy questions about implementing or customizing some writing or whether or not a change you're making is compliant with the law, rather than getting referred out to outside counsel. If you're one of our CSBA legal services clients, you can always contact us or the consultants can put you in touch with us and we can help you out with that. So it's just one more way that we can help out our members. And that's part of why we designed this service is really to extend the benefits of CSBA membership and how we can serve you all. So that's why Mariela and I are part of this webinar. And we're honored to join the rest of you. And I'm going to actually turn it over to Mariela right now so she can talk about some of the changes in law that impact these policies we're talking about today.
Thank you, Bob. And again, good morning, everyone, and thank you for joining us today. I am going to very briefly discuss two bills, and Barbara will then discuss more at length how they impact certain board policies and administrative regulations. But let's start off with SB 532. It amends the Education Code, and it was signed into law on September 30th, 2022. SB 532 expands and strengthens the exemptions from graduation requirements for highly mobile student populations. And what that means is actually set forth in the Senate bill. And the Senate bill requires districts to annually report to the California Department of Education the number of students who graduated with an exemption from district established graduation requirements during the prior school year. And it provides for additional requirements regarding the transfer of coursework and credits, exemptions from district established graduation requirements, and for the option to remain in school to complete district established or statewide course requirements for an additional year. So 5 years in high school. So that's my little summary of that bill. And I'll turn it over to Barbara now for a discussion, like I said, of the board policies and the administrative regulations that are impacted by it.
Thank you, Mariella. Now we will look to see where SB 532 fits into policy, as well as to discuss other updates that were made to those policy materials. So let's look first at board policy 6146.1, which is called high school graduation requirements. And we'll start with SB 532, since that is fresh in our minds. It was incorporated into the section called exemptions from district adopted graduation requirements. And the pertinent portions to this policy are the requirement to exempt from district established graduation requirements highly mobile students, which are foster youth, students experiencing homelessness, former juvenile court school students, children of military families, migrant students, or newly arrived immigrant students participating in a newcomer program who were not properly notified of an exemption, declined the exemption, or were not previously exempted upon request by the student or the person holding the right to make educational decisions for the student. And after this, we will refer to those students as highly mobile students. Also pertinent is the requirement to annually report to the California Department of Education, as Mariella just described. Other changes that were made to 6146.1 include changing language from homeless student to students experiencing homelessness. And this is in keeping with how the term is used in state law, and adding material regarding the prohibition against requiring highly mobile students who are exempted from district established graduation requirements and who complete the statewide coursework requirements before the end of the 4th year of high school and would otherwise be entitled to remain in school to graduate before the end of the 4th year of high school. Now let's look at board policy and administrative regulation 6173, education for homeless children. Again, we'll start with SB 532. To the board policy, we add the reporting requirement to the California Department of Education, and to the administrative regulation, we added the additional requirements related to the transfer of coursework and credits, which was included in the section transfer of coursework and credits, and the expanded obligations related to exemptions from district established graduation requirements, which were added to the section applicability of graduation requirements. Next slide, please. Other changes to the board policy include incorporating AB 408. So just a little bit of background. Federal law already required policy to remove barriers to identification, enrollment, and retention of homeless children, ensure homeless students are not segregated or stigmatized, provide for professional development, and ensure transportation is provided to and from the school of origin. AB 408 establishes a state mandate that districts establish homeless education program policies consistent with state law and utilizing resources developed by the California Department of Education on homeless educational technical assistance centers, and that these policies or policy be updated at least once every 3 years. AB 408 also requires the liaison for homeless students to offer annual training to district employees providing services to students experiencing homelessness, and to inform such employees of the availability of training and the services provided by the liaison. We also incorporated to the board policy AB 2375, which requires districts, regardless of whether they received American Rescue Plan Act of 2021 funds, to annually administer a housing questionnaire for the purpose of identifying students experiencing homelessness, including unaccompanied minors, and annually report that number of students to the California Department of Education. Other changes to the administrative regulation include incorporating AB 408, which was just explained in regard to the board policy, reflecting AB 181, which requires the district to waive transportation fees for unduplicated students, since it is likely that most students experiencing homelessness would be eligible to receive free meals and would therefore qualify as an unduplicated student. Students experiencing homelessness would most likely be exempt from transportation costs. We also included the prohibition against requiring a student who is eligible for an exemption from district established graduation requirements from accepting the exemption or being denied enrollment, as well as the prohibition against revoking a student's exemption from district established graduation requirements, and the prohibition against requiring a student experiencing homelessness who is exempted from district established graduation requirements and who completes the statewide course requirements before the end of the 4th year of high school and would otherwise be entitled to remain in school to graduate before the end of the student's 4th year of high school. As with 6146.1, we also changed with how the term is used in state law and are using the term student experiencing homelessness. Last but not least, as part of our discussion on SB 532 is Board Policy and Administrative Regulation 6173.1, Education for Foster Youth. In regard to SB 532, there is not much new for discussion, as the changes to the board policy and administrative regulation pretty much mirror the changes made to 6173, Education for Homeless Children. So let's look to just a few other changes. In terms of the board policy, the only other significant change is that we moved material regarding a safe learning environment toward the beginning of the policy due to its philosophical nature and its general implications. And in terms of the administrative regulation, we included AB 181, which amends the definition of foster youth, and secondly, requires districts that provide home to school transportation and other transportation expressly provided by law to waive transportation fees for foster youth. And we also included AB 740. But before going into a discussion of AB 740 and implications for policy, I'm going to hand it over to Mariella to discuss the bill summary and legal implications. Next slide, please.
Thank you, Barbara. Like Barbara said, we're going to turn to AB 740 now, which also amends the Education Code and was signed into law on September 18th, 2022. And this is quite a long bill, but I'm going to highlight what for our purposes is of most importance. So first of all, it extends to a foster youth's attorney and county social worker and an Indian child's tribal social worker and, if applicable, the county social worker for the Indian child, required notifications regarding involuntary removal of the student from a charter school. In addition to that, it provides that these individuals that I have just outlined, with the addition of a foster youth educational rights holder, that they have the same rights as a parent or guardian to receive a suspension notice, an expulsion notice, a manifestation determination notice for students with disabilities, and an involuntary transfer notice. And finally, this bill, AB 740, provides for additional due process procedures for suspension of foster youth and Indian children. So that is my brief description of AB 740, and I'll turn it right back to Barbara.
Okay, so let's look at some policy again. In regard to AB 740, policy updates, let's first look at Board Policy and Administrative Regulation 0420.4, Charter School Authorization. And of course, again, we'll start with the AB 740 implications. In the administrative regulation, we added to the section components of charter petition and specifically to item number 11 that speaks to procedures by which students can be suspended or expelled for disciplinary reasons or otherwise involuntarily removed for any reason, the requirements of AB 740 as Mariella just described. In the same item, we also expanded the material regarding procedures for suspension and expulsion, or I should say suspension or expulsion, including the requirement for written notice of the intent to remove the student and the right to initiate a hearing, and material related to processes for notification to the district when a student is expelled or leaves the charter school without graduating or completing the school year. Other changes to the board policy include the prohibition against approving a petition for the establishment of a new charter school offering non-classroom based instruction until January 1, 2025. And as a little history, this was just extended from which originally had a 2022 deadline. Providing that a district under state receivership is not in a position to absorb the fiscal impact of a proposed charter school. And we also reference pending litigation brought by each of CSBA's Education Legal Alliance and Napa Valley Unified School District against the State Board of Education regarding the state board's authority to reverse the denial of a charter school petition by making a determination that a board abused its discretion in denying the petition. Other changes to the administrative regulation include expanding the material regarding the final audit when a charter school closes. Okay, so the next one we will look at is Administrative Regulation 5144.1, Suspension and Expulsion Due Process. AB 740 was worked into the section on due process procedures for suspension, where we discuss additional procedures when considering suspension of a student who is a foster youth or Indian child. It was also worked in the section regarding on-campus suspension, where we include that a foster youth educational rights holder, attorney, and county social worker, and an Indian child's tribal social worker, and if applicable, county social worker, be notified at the time such a student is assigned to an on-campus suspension. It was also incorporated into the section regarding additional notice of expulsion hearing for foster youth, homeless students, and Indian children by expanding the individuals who are required to receive notification prior to conducting an expulsion hearing. We also made changes consistent with the intent of AB 740 to the section on readmission after expulsion. Next slide, please. Other changes to the administrative regulation include providing that suspension does not include removal from class, so long as the removal from a particular class does not occur more than once every 5 school days. We added definitions related to electronic acts as a mode of bullying. We included that a teacher may, in addition to suspending a student from class, refer a student for specified acts to the principal or designee for consideration of a suspension from school. And we also clarified that immediate suspension is required for any student found at school or school activity away from school who committed any of the enumerated acts for which a recommendation of expulsion is required. The next part of our discussion will focus on Administrative Regulation 5144.2, which is suspension and expulsion due process for students with disabilities. As usual, we'll start with our bill of focus, which is AB 740. And we work this into the section on manifestation determination, specifically that a foster youth educational rights holder, attorney, and county social worker, and an Indian child's tribal social worker, and if applicable, county social worker, have the same rights as a parent guardian, as Mariella said, to receive a suspension notice, expulsion notice, manifestation determined notice, and invitation to the manifestation determination meeting when applicable, involuntary transfer notice, and other documents and related information. Other changes to this regulation include reflecting new guidance from the U.S. Department of Education's Office of Special Education and Rehabilitative Services, which recommends that districts identify ways to significantly reduce the use of exclusionary discipline and its disproportionate effect on students with disabilities, as well as new guidance from the U.S. Department of Education's Office for Civil Rights, which provides that for a student with a disability under Section 504, schools are required to conduct a manifestation determination before implementing a disciplinary removal that will significantly change the placement of the student due to discipline for either removal from a class or school for more than 10 consecutive school days, or a series of removals from class or school that together total more than 10 school days in a school year and constitute a pattern of removal. We also emphasize that suspension or expulsion of a student with disabilities be in accordance with Board Policy 5144.1, which we just discussed, and that when a student with disabilities exhibits behavior which impedes the student's own learning or that of others, the student's individualized education program team consider positive behavioral interventions and supports and other strategies to address the behavior. Last but not least, the only part of Administrative Regulation 6173.1, Education for Foster Youth, that we did not discuss earlier has to do with the AB 740 implications. And this occurred specifically in the section on district liaison, where we expanded the individuals who are required to receive notifications related to suspension, expulsion, manifestation determination when applicable, and involuntary transfer to include a foster youth educational rights holder and social worker. Next slide, please. And now I'm going to turn it over to Tazita to discuss Board Policy 4030, non-discrimination in employment.
Thanks, Barbara. As Barbara mentioned, we're going to be talking about Board Policy 4030, non-discrimination in employment. There was one key change to this policy in addition to some minor changes. I'll be focusing on the key change, which results from Senate Bill 523 of 2022, which modifies or amends government code to include reproductive health decision-making. So as you can see, reproductive health decision-making includes a person's decision to use or access a particular drug, device, product, or medical service for reproductive health. Reproductive decision-making is now protected from discrimination, along with actual or perceived race, color, ancestry, national origin, age, religious creed, marital status, pregnancy, physical or mental disability, medical conditions, genetic information, veteran or military status, sex, sexual orientation, gender identity, or gender expression. And specifically, employers are now prohibited from requiring an applicant to disclose any information. So the specific practices prohibited include any requirement to disclose information related to or about an employee's reproductive health decision-making choices. So this is, like I said, a short but key change to non-discrimination. And that about sums up my section. So I'm going to pass it over to Dustin, who's going to be focusing on our board policy updates or administrative regulation updates to 5131.41.
Thank you, Tazita. Administrative Regulation 5131.41 was updated following a December 2022 resolution agreement between Davis Joint Unified School District and the U.S. Department of Education Office for Civil Rights. Following an investigation into the use of seclusion and restraint at a non-public school that Davis students were attending. These revisions were made based on policy revisions agreed to by Davis USD and the Office for Civil Rights. The first bullet incorporates the language from AR 6159.4, Behavioral Interventions for Special Education Students. Additionally, the statement, staff may not apply seclusion or restraint to students with disabilities based on assumptions or stereotypes about disabilities or students with disabilities, or for behavior that would not result in restraint or seclusion for students without disability, was also added. Because of the risk to harm to students, staff, and property, a statement to provide training to the staff in the safe and effective use of seclusion and restraints was also added. Finally, consistent with Education Code 56521.1, notification and documentation requirements were added to this regulation. Parent and guardians, and if appropriate, residential care providers shall be notified within one school day whenever an emergency intervention is used or serious property damage occurs. Additionally, whenever seclusion or restraint is used or serious property damage occurs, a behavior emergency report shall be completed and forwarded to the superintendent or designee for review. The regulation also lists the required documentation information such as times and location and what happened. On the next slide, please. There we go. Even though students were attending the non-public school, not Davis schools, the key finding in the OCR investigation found that Davis denied students a free and appropriate public education because they failed to ensure that non-public school staff were knowledgeable about district policies, procedures, and practices regarding the use of seclusion and restraint. Additionally, the district was found to have failed to reevaluate students to determine if the repeated use of seclusion and restraint affected their receipt of a free and appropriate public education, or if any additional aids and services were appropriate. So policy 6159.2 states that during the period when any student with a disability is placed in a non-public school or agency, the student's IEP team shall retain responsibility for monitoring the student's progress towards meeting goals identified in their IEP. This means it is the district's responsibility to ensure non-public school staff are trained in and comply with district policies, procedures, and practice when serving district students. It is also the district's responsibility to ensure the use of seclusion or restraint on district students is documented in accordance with the district policy and applicable laws. It is also the district's responsibility to reevaluate district students after repeated use of restraint and seclusion to ensure the receipt of a free and appropriate public education, and if any additional aids and services are appropriate. So that incorporates the revisions to that regulation. Now on the next slide, AR Administrative Regulation 6115 was updated to include Juneteenth as one of the days designated as a holiday on which districts must close schools. In 2021, President Biden signed into law a federal bill allowing Juneteenth National Independence Day, commemorated on June 19th, to the list of federal holidays. AB 1655 of 2022 thus added Juneteenth to the list of holidays on which public schools must be closed. Assembly Bill 1655 also amended to note that districts are not required to close on Columbus Day. We also updated AR 6115 to include 2 days of special significance on which schools are encouraged but not required to conduct commemorative exercises. One of these is Genocide Remembrance Day, which falls on April 24th and was added by Assembly Bill 1802. The other is September 11th, Remembrance Day, which was added by Senate Bill 254. Next slide, please. Finally, I wanted to share about Board Bylaw 9270, conflict of interest. Senate Bill 1439 extended pay-to-play regulations to local elected officials, including school boards and agency heads, which likely includes superintendents. What this bill specifies is that a board member who has received a campaign contribution of more than $250 within the prior 12 months from a party or participant involved in a proceeding must disclose the contribution on the record and may not participate in the decision. Next slide, please. A board member may not accept, solicit, or direct a contribution of over $250 from a party or participant involved in a contract pending before the board. The exception to this is a board member who receives this disqualifying contribution may participate in the decision if they return it within 30 days of when they knew or should have known of its receipt. Next slide, please. Next, this bill states that a board member may not accept, solicit, or direct a contribution of over $250 for 12 months after the final decision on the contract. If accepted unknowingly, the board member may avoid penalties if they return it or any amount in excess of $250 within 14 days of soliciting, accepting, or directing the contribution. Finally, or next, a party or participant in a proceeding may not make a contribution of over $250 during the consideration of the contract or for 12 months after the decision. Next slide, please. A couple more points here, and then I'll try to give you a summary of what this means for you. A party or participant must disclose on the record any contribution over $250 made to a board member within the past 12 months. These restrictions I just discussed, the exceptions to those is labor contracts, competitively bid contracts, and personal employment contracts. The key idea here is that from 12 months before to 12 months after a proceeding involving a license, permit, or other entitlement, including a contract, board members and superintendents cannot accept gifts of more than $250 from those with a financial interest in the decision. So we'll have time at the end if you have more questions about that. And in the meantime, I'll turn it over to Bob.
All right, thank you very much, Dustin. So I'm going to cover a couple of bills here, AB 2447 and AB 2647, that impacts your meetings and notices, or school board meetings and notices. I'm going to talk about these bills in the context of the policy because I think that's sort of the easiest way to explain and cover all the material here. Essentially, what AB 2449, what it does is expand teleconferencing to basically give 4 different avenues for appearing remotely at a school board meeting. We have our traditional teleconferencing under the Brown Act that's existed for years. And then as COVID came along, we had a series of executive orders that sort of suspended some of those rules and changed the rules to allow remote appearances under less strict conditions. Those were eventually reflected in AB 361, which allowed teleconferencing during a proclaimed state of emergency. Now, even though our proclaimed state of emergency regarding COVID has expired, that's been stayed by the governor, AB 361 does apply to emergencies that arise under Government Code Section 8558. So that would include things like fires, floods, earthquakes, those kind of emergencies. So while COVID has been, that emergency has lapsed the declaration, additional or other emergencies could still be declared. And if they are, you can invoke the provisions under 361 until December 31st, 2023. These are all laid out in the policy or in the bylaw itself. Those are not new to this, so I won't go into them in great detail today. But what I do want to talk about are the next 2 bullets on here, which is the individual teleconferencing avenues that you can use for personal emergencies or for just cause. Those both come out of AB 2449, which also has a sunset date of December 31st, 2025. So until that date comes along, you'll be allowed to use these teleconferencing provisions. Now let's talk a little bit about what those are. Next slide, please. Okay, so under 2449, you have basically 2 different avenues that you can take for teleconferencing as an individual. Those are, the first one is teleconferencing during a personal emergency. And this refers specifically to a physical or family medical emergency. So if you do get COVID or a member of your family gets COVID or some other medical emergency occurs that makes it so you're not able to attend the meeting in person, you can invoke this aspect of 2449. This one does require approval from a majority of the board. So what happens is the board member who wants to appear telephonically needs to notify the rest of the board of the emergency situation as soon as possible. You're not strictly required to do this in writing, but you do have to provide a concise general description of the circumstances that are causing you to need to appear remotely. It's not necessary that you disclose any personal information about disabilities or medical diagnoses or anything that might be covered under HIPAA, but you do have to notify the board of why you are seeking to appear telephonically or through teleconference, and they have to make an approval of that request. Next slide, please. This particular aspect of the 2449 teleconferencing can only be used for up to 20% of your school board meetings, and it cannot be used for more than 3 consecutive months. So there are some limitations on how frequently you can use it. If your board meets fewer than 10 times or 10 times or less, the emergency circumstances provision can only be invoked for 2 meetings. So that's consistent with the 20% of the regular meetings, but doesn't allow you that third consecutive month period. Next slide, please. The second prong of AB 2449 allows for teleconferencing for just cause. What just cause means is defined in the statute, in the government code now. And it's these 4 provisions here: childcare or caregiving need of a child, parent, grandparent, or other dependent who that requires the board member to participate remotely. A contagious illness prevents the board member from attending in person. So if you do have COVID, you can't attend in person without spreading the illness, then you can invoke this. A board member has a need related to a physical or mental disability that's not otherwise reasonably accommodated. But this one's a little tricky. Remember that you do have to comply with the Americans with Disability Act and provide reasonable accommodations for people to attend meetings. But what this really gets to is more things like perhaps depression or something of that nature that has come up during the last month or so. And so the board member has to invoke this because they cannot be reasonably accommodated to otherwise attend the meeting. And then the 4th one is for when a board member is traveling on official business. That could be a business of the school board itself or a business for another state agency. In any one of these situations, they can invoke just cause. And in order for them to do that, the board member needs to notify the rest of the board as soon as possible that they're going to need to appear telephonically or by teleconference. And that as soon as possible could actually be right up into the start of the meeting itself. And in the just cause instance, the board does not have to approve this request. You simply have to notify them of it, but the board approval is not required. It can be invoked up to 2 times per calendar year per school board member. So what happens when you invoke either of these, either just cause or the emergency provisions? We'll talk about that and the change of the rules on the next slide. So what it really does, it suspends some of the requirements for posting and then adds a few additional rules regarding how you make votes and how you actually appear. So first and foremost, you no longer have to participate remotely from a location that's accessible to the public. It's very similar to how we operated under 361 and during the executive orders regarding COVID. The locations do not need to be identified on the agenda, but you do have to use both audio and visual technology when you are appearing remotely. So that would mean you're calling in on Zoom and using something like that, or Teams, or one of those kind of things where it allows you to be seen and heard. And the district also has to provide public access to the meeting via that 2-way audio visual platform as well. Public comment has to be allowed through that platform, and you have to provide information to the public as to how they are going to access that platform and what the platform would be. Next slide. So the agenda itself does have to include information describing how the public can access the platform. It doesn't have to list those locations again where the board member will be appearing by, but it does have to list how the public can engage in the meeting in the same manner that the board member is. So the other major provisions that are changed here is before any action is taken, and this is completely new. This is not part of 361 or the prior, the traditional teleconferencing rules. Before any action is taken, a board member has to disclose publicly any other individuals who are in the room with them that are 18 years or older, and they have to describe their general relationship to the board member. This is something, like I said, that's new and unique to AB 2449 provisions. And it's one that is probably one where you can get tripped up. So just a reminder to you as you're conducting those meetings, before you take that action, a board member may forget they need to make this declaration. So a gentle reminder from the school board president or person calling for that vote would be helpful in these instances. And then also, if you have a disruption in your broadcast, that prevents the public from being able to participate in the meeting or offer public comments, you have to suspend taking any actions on the agenda until that disruption has been resolved and public access to the meeting has been restored. Next slide, please. So those are the major provision changes under 2449 dealing with teleconferencing, but there were some additional things that were added by AB 2449, specifically around disabilities and access. And essentially what it requires, similar to what the ADA requires, is the boards have to maintain and implement a procedure for receiving and resolving requests for reasonable accommodations. Any doubt about those requests for accommodations need to be resolved in favor of accessibility, and those procedures need to be included on your agenda. You already have a requirement to include information about disabilities and access on your agenda, and this expands that to include these new provisions and the new procedures. Next slide. Okay, and so Board Bylaw 9320 was revised mostly because of AB 2449, but we also have this other bill 2647. This one's a little bit complicated in its nature. It actually grew specifically out of case law, out of a case called Sierra Watch versus Placer County. It wasn't a school-related case, but it was a public meeting related case. So basically what this law allows and what the edits to the board bylaw provide is that you can now have some flexibility around providing materials to the public. Under the Brown Act, you have to provide materials to the public 72 hours before the meeting. And that applies to any materials that are applied to or provided to the school board. They also have to be provided to the public. Under this new law, if certain circumstances are met, you can actually post the materials online, so long as you make them available at your earliest business hours following the posting. So the requirements are listed out here. You have to first make an initial staff report or some similar document that contains an executive summary of the item itself and any staff recommendations related to that item. That document has to be posted on the internet website in a location in a manner that makes it really clear that it applies to an agenda item from an upcoming meeting. You have to identify where that is going to be located on your agenda. And then once you do open back up for business, you have to make copies available for public inspection. Those copies have to be still available at least 24 hours before the meeting. So really what this allows for is if you have a situation where there's going to be documents attached to an agenda item, those documents aren't available until after you've closed your office hours, and therefore the public can't get into the building. You can post them online, and then you can still have this flexibility as long as you are making those documents reasonably available under these conditions. It's going to be a pretty specific instance when this happens. It is a kind of technical revision and change. So if you have questions about it, please feel free to reach out to CSBA and we'd be happy to help with. Next slide, please. And now we'll turn it over to Tazita, and she can talk about our county samples and how this update packet will impact the county sample manual.
Thanks, Bob. So as you all may or may not know, CSBA maintains two distinct versions of our samples. In some cases, we have created specific policy language for counties. The current CSBA sample county manual is composed of about 83 county-specific board policies, regulations, and bylaws. The remaining samples that we provide access to are written for districts, but they can be adapted for your use if you work for a county office of education or you support a county office of education. And what that means is that there's kind of a distinction between our packets when we release them. So this March packet, we released the update for districts on March 16th. What we try to do to prevent miscommunication or confusion is we release the county-specific policies when there are county-specific policies being updated about a week after that first update packet goes out. So this time around, you would have seen the district release again on March 16th, and then the following Wednesday, we sent out a notice letting you all know that we updated county policies as well. So the way to distinguish kind of what is a district language versus a county-based policy or a county-specific policy is through our first note box at the top. So if you're looking at the sample policies, you'll see this disclaimer on anything that had been written specifically for a district, but is available for use by a county office. And so this disclaimer basically says, in a nutshell, that the document may or may not include global changes. So you would need to pay attention and be modifying anything that says superintendent or to reflect county superintendent, or you might change the title of the board to county school board, et cetera. In addition, there are different types of designations that counties can use. For example, the superintendent policy would be another type that's only available to county offices of education. And so those are available to make those modifications to tailor the policies to fit the county needs. If you have any questions about how to do that, how to engage with them, what kinds of edits you could or should be making, you can always contact our team and we're happy to walk you through those. But this time around, we revised the following specific policies that were written for county offices of education. And the reason why it might look a little different from a district is that sometimes the provisions that we're basing our updates off of come from different areas of statute, or there are just simply different requirements that a county office of education would need to adhere to. So this time around, we released Board Policy 0420.4, authorization of county charter schools. There's BP and the exhibit for 3555, which is nutrition program compliance. The administrative regulation for 5113, absences, excuses, and the BP and administrative regulation for 6173, education for homeless children. The final two are board bylaws, and that's 9270, the conflict of interest, and BB 9320, meetings and notices, which Bob just summarized for us. So we wanted to make that clear. If there are any questions about the policies themselves, the samples, how to access them, find them, distinguish one from the other, we're happy to walk you through that process, as well as tailoring those to the specific needs of your county office of education. So with that, that summarizes our presentation for the morning, and we'd like to open it up for questions that you all may have, either technical questions about the system or any of the policies that we reviewed. So I'm going to go briefly to the Q&A section. And the first one we have is from Bruce. And the question is around 9270, and that's conflict of interest. And specifically is asking, does 9270 or the changes to 9270 impact PAC payments, so political action committee payments?
I'd be happy to jump in on this one. So first of all, I think it's important to note that this law is already being challenged. Interestingly, it passed, I believe, unanimously, and these restrictions had been in place for other elected officials, and 1439 expanded it to school board members. So it's any contribution that meets those requirements is how 1439 is structured. So it would apply to a PAC payment subject to those for the individual election, right? Subject to those requirements. That's assuming that this is upheld. The FPPC hasn't weighed in specifically on that issue. And again, it's being challenged. So stay tuned on that one, and we'll be, I'm sure, updating you as this goes along through both our legal department, our general counsel's office, as well as our legal services program, because this is an evolving issue, but great question.
Okay, and then we have a couple questions on 9320, meetings and notices. So I'll read the first one, and then there's a follow-up question. Also from Bruce, does 9320 restrict traditional requests by board members to attend via Zoom in non-emergency situations? For example, out of town on non-board related business. So the distinction here is non-board related business. Would anyone like to take a stab at that?
I'm happy to answer it. I'm just reading the question here just to make sure I
Okay.
got the whole question. Restrict
Sure.
traditional group.
And I'll read it out loud again for
Okay.
participants. Does 9320 restrict traditional requests by board members to attend via Zoom in non-emergency situations? For example, if a board member was out of town on non-board related business, are there any additional restrictions to those accommodations to attend via telephone or via Zoom?
Got to understand. So you can still invoke the traditional Brown Act teleconferencing rules if you were going to appear. So if you're traveling for non-school related business or non-official business, and you want to appear remotely at the school board meeting, you're still allowed to do that, but you have to adhere to the traditional requirements, which include posting a copy of the agenda and the notice at the location you're appearing from, making that location available to the public, as well as including that location on the agenda itself. So if you're going to appear remotely, that agenda has to say, Trustee Dennis will be appearing remotely from X location. Here's what the agenda says. Then at that location, you have to post that agenda and allow the public to participate. And the other restriction there is that you cannot have more than a quorum of well, let me rephrase that. You must have a quorum of your board appearing within the jurisdictional boundary of the school district or county office.
Okay, and you cut out there, Bob, but I think you just said basically that a quorum of the board must be present within the boundaries of the district during the meeting.
Correct.
Okay.
And I just want to clarify too, that we do have a section in that bylaw about traditional teleconferencing and the requirements that are in there. So yeah.
Thanks, Barbara. So there's a part 2 again on meetings and notices, and this is from Colleen. Are we required to provide the public with an option to participate telephonically or via telephone?
If you are doing one of these teleconferencing appearances under 2449 or 361, yes, you are. And it has to be both audio and visual. Same platform that the board member is appearing by. And I'm not surprised we're getting a lot of these questions. Actually, this is probably the #1 thing we've gotten questions on in legal services recently. If you are a legal services client, our legal resource library has a really handy chart on this that kind of spells out which of the different teleconferencing provisions you can use and what the rules are specific to those. But generally, yes, if you're going to appear telephonically under 361 or 2449, then you have to allow the public that same option to do it. If you're going to appear under the traditional teleconferencing rules, you do not necessarily have to do that. Hopefully that answers your question.
Thanks, Bob. Okay, so the next question is from Shari, and it's pertaining to 5144.2. So the Shari's asking that, or mentioning that there's a mention of 504, but no mention of IEP and the manifestation requirement. Can you clarify the difference for 504 versus IEP? Some students are 504 and not on an IEP.
Sure, yeah, I can take this. So the difference is that it was always clear that for IEPs, a manifestation determination requirement is there. So that was always kind of more known for IEPs that meeting had to occur. The new part was the guidance about the 504s, that it is also required that a manifestation determination meeting is required for 504 students as well. So in other words, I didn't mention both initially, but the end result is it's required for both 504 students and IEP students.
Thanks, Barbara, and I hope that answers your question, Shari. The next is from Rose. I'm still confused about the updates for the county. So I can add a little clarity, hopefully, and then if this doesn't get at your question, you can let me know if there's something more specific. So we release at times county-specific versions of the updates. For example, authorization of a charter school, 420.4. There are 2 different versions of that document because there are different requirements for a county office of education than there are for a school district. When there is specific language that affects a county board but does not affect a district, we create, in essence, a county version of that policy. The manual that the county policies are housed in is called the County Sample Manual, and it contains sections 0 through 9,000. Some of those policies are county specific, meaning written explicitly with the intention of this is for use by a county office of education with specific language that points to statute or requirements or issues that will only come up for a county office of education. But then there are other policies that county offices of education can use that have been written for districts, but you can modify them to reflect that they are being used at a county office of education. So that might be something like, I don't know, I'm just pulling one out of the hat, sun safety, right? So that policy wouldn't be written specifically for county offices of education, because if there are programs that the county office is offering and that they are providing services to students, you could just modify that district written language to reflect that it is applicable to a county office of education. So you would change some of the language around the county superintendent or the county office of education. You could substitute the word district for that language in that policy. So basically there's 83 of the policies that have been written explicitly for county offices of education. The remaining policies in the County Sample Manual have been written for districts, but can be adapted for use by county offices of education. And as we update those 83 specific county policies, you'll see them come out in separate update packets. So we have one update packet that goes out for districts, and that contains all the updates that we're making to the district policies. And then we have a subsequent packet if we're updating any one of those 83 policies that are written specifically for counties that we issue separately. So if you're still having some confusion about the types, where they can be found, how you modify them, we're happy to help you work through those questions. And you can reach out to us at policy@csba.org. So I hope that gets at your question, Rosie or Rose. Did anyone else have any context they wanted to add to the county policies?
Yeah, I just wanted to say one thing to just that it's not always just a substitution for terms and names. Sometimes there is a difference in law or application, like you were saying before. So just to be a little sensitive when it's adapted. Yeah.
Thank you, Barbara. That's a good point. All right. So the next question is from Anne. Are you able to send us an updated list of BPs and ARs that have been deleted? So this is a little bit more nuanced. I would say that whenever CSBA is, and we don't do this often, deleting a policy, I believe that's summarized on the checklist if it has been deleted, but if there's language that moves, you might see just that the language has been updated in a policy. So we don't provide a summary list of deletions, but you would see any deletions happening, showing up on the checklist that we provide for each update packet. Any other context there, Barbara, we can offer for deletions?
Well, yeah, and if it's something that a district would want to go back historically, we could provide, like from the master guide sheet, we could provide historical policies and regulations, exhibits that have been deleted.
Sure. So, and if there's something specific you want us to check on, right, because that's happening over kind of a long period of time. So the way we track it internally is not the same way we provide access to you. But if there was something specific that you wanted to know, well, was this deleted or when it might have been deleted, we can do that kind of research for you and get you information that you're looking for. But no, there is no one specific document that we would share that tracks kind of anything that's been deleted. Those happen on a regular basis with each checklist. All right. So I have a question from Stacy. Does the system have a way for districts to download a digital copy of their district policy manual other than downloading each policy one at a time? And if not, is that a feature that might be available in the future? And I can answer that one. Yes. So if you're using Gamut Policy Plus, which I imagine you are, there's a way to download all. So it's a feature that already exists. It sometimes takes a little while. You can imagine with 600-700 plus documents, converting all that into PDF might take more than just a minute or two. So what happens is the same way you might click to download an individual policy, there's a setting where you can download all, and it alerts you in the top menu bar once the whole manual is done downloading. So it allows you to decide if you want to add page numbers or watermarks, or there's different kind of ways you can build the manual, but ultimately at the end, you'll see a bell in the top menu bar of Gamut that alerts you when the policies are done downloading. So it is a feature that's available now. If you're struggling with it or haven't found access to it easily, you can contact us at gamut@csba.org and we can walk you through that process. Okay. There's another question, and it's around, can we give an example of AB 2647 and distributing materials to the board less than 72 hours before the meeting and outside of regular business hours? So I think,
Sure.
Okay.
I can jump in on that one. I'll do my best to quickly recount what I can recall of the Smith case, which is the one that spawned this legislation. In that instance, essentially what had happened is, I believe it was a city municipal government, if I remember right, maybe it was county, I can't recall, but they had an environmental impact statement and a settlement related to that on their agenda. They were working late into the hours to try and get the settlement resolved, and once they did, the actual settlement document became available, but it was after 5 o'clock. So their business office had closed, and therefore the ability for the public to get a copy of that document stopped at the moment that those doors were locked, right? So the doors were locked. It was Friday night. I think it was shortly after, it was within an hour or so that the settlement document became available. They distributed that document to the board members, but not to the public. So at this point now, we violated that 72-hour rule. The board has it, the public doesn't. And then they made it available at the beginning of the following week, but the court came in and said, this actually still is a violation of that 72-hour law. And so you have to pull this off of your agenda because you're not giving proper notice. So that's exactly what happened to kind of spawn this new law that says, okay, in these circumstances, when you're going to have a document that's getting attached later, if you follow these very specific steps, you can use the internet to provide access to that, as long as you're providing the physical access at the beginning of your next business hours. So hopefully that helps. It's kind of a complicated law and a complicated case, but again, we're happy to explain in specific instances if you have questions about it.
Thanks, Bob. Okay, from Colleen, is there a policy regarding employees' personal social media restrictions? Anyone want to add some context here? I'm thinking, technology related things, but nothing is coming up for me as far as personal social media. Barbara?
We do have just a small part in 4040 employee use of technology.
Mhm.
And that is mostly in regard to if an individual or an employee were to use their personal device to conduct business, like business matters, that it could become subject to like a Personal Records Act request. So in that way we do. We don't have anything like specific to a personal social media. I believe in a board bylaw, we have something similar also, but in terms of an employee, I think that's it. I could research further. That's the one that comes to mind.
I would agree. And I think specifically, we don't have anything around restrictions on their personal media, social media use.
Correct. Not restrictions, but more like what can occur if it is used.
Got it.
But that's more just to conduct district business, not for other matters that might be happening on social media.
Thanks, Barbara. Anyone else want to chime in on that one? Okay. Our next one is from Oscar, and it's regarding 4218, dismissal, suspension, disciplinary action. The question is, if we are not a merit system district under compulsory leave of absence, are we okay with leaving the content as is based on CSBA recommendation? So for non-merit districts, I think if I understand the question, do you have to take the edit, or do you need to modify the content if you are a non-merit district under compulsory leave of absence? Anyone want to jump in on this one? So it's probably something that I would say I'd want to take a look at a little bit closer, Oscar. I'm going to put our email in the chat, and let's follow up after this to see if there's anything applicable in there for non-merit, or if we have any other recommendations. So I'll put that email in the chat for you, and then we can follow up after the call.
And I think we'd also want to take a look, Oscar, at your specific policy, because this is germane to the CSBA samples. And so to leave it as is based on what your district is, we'd have to know specifically what your district policy says. So
Thanks, Bob. So we have another question. Is there a policy regarding employees obtaining employment outside of the workday? And I'm not sure I understand the question. If this is your question, a little more context might be helpful, but I guess how I'm understanding it is you might be thinking about outside employment for employees. And I don't think we have anything that specific that would say or restrain or recommend or anything that would really address outside employment for staff. But is anything coming up for anyone else?
you know, I think there may be some language, vaguely this is coming to mind, that there may be some small language in one of the policies, but I think if you want to email us, email policy@csba.org. Outside of this, we can do a little bit of digging on that and see what we can find to help you out.
Okay.
I just wanted to add, we do have a policy, and I believe an administrative regulation also, 4136, which is non-school employment. So we could look at that more carefully to see if that addresses the question.
Okay, Barbara, can you repeat the policy number, and I'll put it in the chat to that.
Sure. It's 4136, and I believe there's an AR also. I believe it's a regulation and a policy.
Thank you. And then I did put my email in there, so if you did want to follow up and we kind of go through and kind of get more specifically, I guess, details around your question.
Yeah, and it does cover tutoring. I know that can sometimes be a question that comes up, but yeah, I think that policy, I think it will answer, but if not, maybe, like you said, to see that we could look further to more specifics.
Perfect. Thank you, Barbara. Do we have any guidance to offer on electronic file retention for students? Google is starting to charge for data storage. So my immediate thought is records is where we'd have any language about records and how they need to be maintained. I can say, you know, we don't, outside of records though, I don't know that we have anything as specific about how to deal with data limitations for kind of cloud services, but it's a really good question. And I think an issue that, I mean, I know personally it comes up for me. So anyone have any other thoughts or recommendations outside of records pertaining to this question?
So I think that definitely student records is the policy to look at in terms of, you know, the records I'm assuming are probably based out of your data tracking system or whatever software you're using for your student records. But it brings up a great point that you want to make sure you are doing some sort of backup. Some of the catastrophes we've seen here in California with wildfires and things that have destroyed physical locations just emphasize how important it is to have some sort of probably cloud-based backup of all of your records and otherwise. As far as the costs and what service to use, that's not necessarily our expertise, but I would say you want to make sure that they're vetted for security first and foremost, to make sure that there aren't security breaches. So unfortunately, we don't have other recommendations as services to use specifically.
And I hope that gets at the question. Okay, so next is from Dee Dee. Related to the updates to 9320 meetings and notices, we've had a highway closure due to an avalanche and snow that prohibits our board member or our board from being able to meet in one physical location. To meet via video conference, we would continue to cite AB 361 teleconference and adopt a resolution similar to COVID meetings, mainly just checking that we don't cite to AB 2449.
Great question. It's nice that the drought is ending, but we're paying the consequences up in the mountains. So you can only use AB 361 provisions and the resolution and all of that if there's a declared state of emergency. So if the governor hasn't declared a state of emergency regarding this closure, then you're going to have to rely on AB 2449 and the emergency provision aspect of that. Your other alternatives are to perhaps cancel or reschedule your meeting, which is always an option. And it depends a little bit. Also, you might want to think about, is this highway closure preventing the entire board from appearing or only one or two board members from appearing? And so if it's only one or two board members, you can always use the traditional version of teleconferencing rules, put that on their agenda and allow them to call in from their home and whatnot. So on specific questions like this, again, if you want to give us a call, we can help with preparing the agenda and making sure that your notices are compliant with the ever-changing rules around the Brown Act. Hadn't changed forever, and now it's changing, it seems like every 3 months. So kind of exciting.
Thanks, Bob. The next question is, can file storage and retention be captured in an AR? And if so, which AR is appropriate? So it would depend on the files you're talking about. Like there are specific protocols for student records, for example, and how and what retention should look like or what storage should look like and the classification of those documents. So if they are pertaining to student records, that would be the area I would recommend. But when we're talking about file storage and retention, it would depend on the type of documents and records that you're wanting to retain. And it sounds like this might be a request for us to develop some language around file storage, maybe related to the previous question about if we have any sample language on the topic. And yeah, so this seems like something we could probably talk about. It seems like a more specific situation. If you're looking to kind of create some language for yourself and want a location for it, we can also assign that. But the CSBA sample language, if we were talking about student records, would be contained in that policy. And
our district records policy in the 3000s also does address retention and retention periods. As far as specific storage, again, though, that's it mentions best practices and that you should be backing this up and what your retention requirements are, but where and how you store them is not specifically spelled out in there. But that would probably be the AR where I would list that to the extent you would need to list it.
Thanks, Bob. Okay, next question is from Sandy. If a board member wants to form an ad hoc committee to review all safety policies and possibly make changes, what is your recommendation? So I see kind of two parts to that question. So it's the forming of the committee itself and how would we recommend you all engage with and or review your safety related policies?
In terms of the formation of a committee, I would recommend looking at Board Bylaw 9130, which is called board committees. And the reason why is if it depends. Okay, so if it's a typical board committee and it includes more than a majority of board members, it will have to follow all the Brown Act requirements. But a board can form a subcommittee as long as it's less than a majority of the board to discuss things like this and bring it back to the board as a whole with their recommendations or their thoughts and perspectives. So in terms of a recommendation of how to do it, I would recommend doing it as a subcommittee and then bringing the concepts from the subcommittee back to the board as a whole. In terms of what to look to, that's harder, but I know CSBA does have a lot of good information about safety and is currently working on creating more resources available. So one place to look at would be to our website, I would recommend. To see, I don't know if you have other recommendations about where to actually go for the content.
Yeah, and I was just going to say exactly that, Barbara, that we're working on updated guidance regarding our safety related policies. And I believe it'll either come out as a brief or a kind of guidance from our research team. And I believe we're slated to do that toward the end of the year. So that's possibly something, and I can put my email in here, Sandy, when we have revised, I could let you know, or you could reach out. But I think everything that you mentioned, Barbara, feels like a great place to
And I
start.
believe on the website now there is a list. I believe we've gathered all of what we consider the safety related policies. So I'm not sure if that's up yet. If not yet, it will soon be.
Yeah, I don't think we've posted anything. So that's kind of the first stage in the revision of the guidance. But I will follow up, or if you want to follow up with me, Sandy, on when that'll be released and what the next steps are, we're happy to send that over. Okay. Mira had a question about, or related to the question about printing the manual. Is there a way to select multiple policies to print together? So kind of like a pack of policies. And yes, there is a way to do that by section. So if you wanted to go series by series, Bob, are you going to say something?
No, I was just looking at the next question. So.
Okay, so there's a way to print out each series at a time. But if you're talking more about like, I want to print one from here, or let's say, for example, the safety related policies, those might cover a couple different sections or series. You would have to print those individually. So there's not a way to kind of like get one long menu and select them all, but you can print one series at a time. So all the zeros, all the ones, all the twos, etc. Hope that answers that one. And I think we're getting to the end here. Dora, can you provide some input on incorporating language from a policy and regulation in an update to another policy and deleting the policy and regulation that was incorporated? CSBA has not deleted the sample policy and regulation I'm referring to. So it sounds like you all are wanting to delete a CSBA or a recommended sample. Let's just say, I don't want to pick on sun safety, but sun safety. You're wanting to delete that and you want to incorporate the language from that policy and regulation into another policy. That is absolutely something you can do in the system. One thing I would just caution is just you're always going to get the edits back to that original policy. And so sometimes it creates a little bit of confusion on the back end when CSBA is releasing the language in, I can't remember sun safety's number, but let's say it's charter school authorization 042.0.4. We're always going to release the language pertaining to charter school authorization in 042.0.4. And if you all are addressing it in another policy, then it would need to be documented kind of where that language has gone on your end. And you'd want to have some way of revising it anytime we process an update on the original policy that had been deleted. So there are some cautions I would take, or precautions I would take if you're going to do that. But anyone else have any thoughts about deleting CSBA sample language and incorporating it into a different policy?
Yeah, I would just emphasize the cautions that you mentioned. If it's language that you want to keep, but maybe you don't want the whole policy, sometimes, we can work with you on this. The consultants can work with you, legal services can on customizing these policies. If you want to keep part of the language, but not the whole policy, sometimes it's best to keep it in the policy that CSBA is going to be updating if it's based on a CSBA sample. And that's exactly for the reason Tazita just mentioned. We're going to issue those updates to that specific policy. Doesn't mean you can't put the language somewhere else, but you risk the possibility of maybe missing that language if you've moved it to a separate policy. In addition to that, you could say you move the language from policy B to policy A, and then we update policy B 3 years from now. You look at that update and say, hey, that's a great policy. I want to keep that policy, and you adopt it. You now have similar language in a different policy, and potentially there's a conflict between that language you've adopted. So certainly it's possible, just something to be done with caution, and just also emphasizes the need to really, don't just blanket adopt CSBA sample policies when they come out. It's important that you're reading them and considering how they imply or how they interact with your existing policy manual and how they apply specifically to your district or county office of education.
Thanks, Bob. And Dora, I will put my email in here just because if there is something specific you're talking about, we can probably assist. So, okay. And I want to also be conscious of everyone's time. It is 12:19. There are a couple more questions. If we don't get to them all, I would like to encourage you all to reach out to policy@csba.org for any questions, but I'll try to just read through the rest of them really quickly. So I think the data storage question was talking about student work, not records. I don't believe that we have a lot of statute governing student work, right? Or policy language around student work. But I believe we've kind of exchanged emails, and I don't have your name, I'm sorry, but if there is something, again, more specific and we could help offline, happy to do that.
And depending on the nature of the work, I'll just point out that under FERPA, that also is a student record potentially if it's grades related stuff. So we can talk more offline.
Okay, would retention policies also apply to board meeting records? So I think we're also still talking about data here and records, and not sure which retention policies we're talking about since we're kind of speaking broadly, but there are policies that relate to record keeping and how to preserve those. So my hope is that we could probably talk more specifically about your context and figure out, but anything broad that we want to say about board meeting records like minutes, agendas, other committee documents?
Absolutely. They are classified as records under the different classifications. So you do have retention policies that apply to those, similar to like your school board policies are class 1 records. So there are retention requirements based on the nature of the records. And the policy number is escaping me off the top of my head, but I know we do have that spelled out. So we can, again, if you email us these questions, we'd be happy to put you in touch directly with those specific sample policies.
Thanks, Bob. And Dora came back and just said, to be specific, they are referring to updating board policy 6146.1 and incorporating language from BP and AR 6146.11 and then deleting point. So they want to take from 6146.11, which is for special, this is graduation requirements. So basically collapsing everything into one policy as opposed to keeping 2 separate policies on graduation requirements.
Yeah, 6146.11 is alternative credits towards graduation.
Okay, so I don't have any recommendations just off the top of my head. I would say that, again, the same criteria we explained before, which is that we're going to consistently update 6146.11. With that information, we would never have the 2 collapse, but I imagine this is probably for just having, like the sake of consolidating, wanting to have everything in one place. Without looking at it specifically, I mean, it's the same caution, right? That we're going to continue to update one policy and you're going to have the language in another, but anything else you want to add given this specificity?
I think this one's a great example, right? If you have, you want to just keep your graduation requirements, policy and regulation, that's absolutely okay. The alternative credits, if there are changes to that, which is quite possible, we're going to issue that under 6146.11. So it would then become incumbent on you when that update comes across and you see that on the guide sheet or that policy come across, it sort of you have to maybe either just be aware of the fact that you've got that information located in different policy or somehow maybe track it so that you're triggered to think, oh, alternative graduation credits, we need to go look at where we keep that in our policy. So that's what I would say about that. And again, generally, if we're issuing a policy update, we have, I don't even know now, Tazita, over 700 or so sample policies. You are not going to have every single one of those policies. But when we issue the updates, it might be worth reading through that guide sheet and thinking about, do we have this policy? Do we have a similar policy? Where might that be? Do we want this policy, right? Just to kind of consider it, because we are 95% of the time, we're changing our policies and updating them because the law changed. Sometimes that's going to apply to you. Sometimes it's not. So it's just sort of it's an organic process. I know not everyone loves policies, and so it'd be great to just put them on the agenda, adopt them and move on, but they really do take some thought and consideration to be done well.
quite a lot of thought and consideration. So I appreciate all the questions. I think Cynthia is the last. And is there a way to add the feature of printing the different policies that result from a search in policies? I don't think that's currently a feature. I will take that note. And Cynthia, if we want to talk offline about trying to get done what you're trying to do a little more efficiently, let's talk through that. But I don't think that that's that print all, from a search is currently an option in the system. So I appreciated all the thoughtful questions today, a lot of ones that made me think. So appreciate also you all coming and spending part of your lunch with us. And we'll be back in June for the next one of these. So if there aren't any other questions, I just also want to thank our panelists for being with us today and for all of their time and for your attendance. So as I mentioned before, the PowerPoint as well as the recording will be sent out to all registrants. So you guys can always look back at those. And if you have any questions or concerns, you can contact us, Bob's team at legalservices@csba.org or at their website, and the Gamut side of things at gamut@csba.org or policy@csba.org. So thank you all, and that'll close us out.